a WikiVidi documentaries production. Don't forget to like and subscribe. Enjoy. Supreme Court of the United States. The Supreme Court of the United States is the highest federal court of the United States. Established pursuant to Article 3 of the United States Constitution in 1789, it has ultimate appellate jurisdiction over all federal courts and state court cases involving issues of federal law, plus original jurisdiction over a small range of cases. In the legal system of the United States, the Supreme Court is generally the final interpreter of federal law, including the United States Constitution, but it may act only within the context of a case in which it has jurisdiction. The court may decide cases having political overtones, but does not have power to decide non-justiciable political questions, and its enforcement arm is in the executive rather than judicial branch of government. According to federal statute, the court normally consists of the Chief Justice of the United States and 8 associate justices who are nominated by the President and confirmed by the Senate. Once appointed, justices have lifetime tenure unless they resign, retire, or are removed after impeachment. In modern discourse, the justices are often categorized as having conservative, moderate, or liberal philosophies of law and of judicial interpretation. Each justice has 1 vote, and it is worth noting that while a far greater number of cases in recent history have been decided unanimously, decisions in cases of the highest profile have often come down to just 1 single vote, thereby exposing the justices' ideological beliefs that track with those philosophical or political categories. The court meets in the Supreme Court building in Washington, D.C. History. The ratification of the United States Constitution established the Supreme Court in 1789. Its powers are detailed in Article 3 of the Constitution. The Supreme Court was the only court specifically established by the Constitution, while all other federal courts were created by Congress. Congress is also responsible for conferring the title of Justice to its members, who are known to scold lawyers for inaccurately referring to them as Judge, even though it is the term used in the Constitution. The court first convened on February 2, 1790, with 6 judges, where only 5 of its 6 initial positions were filled. According to historian Fergus Bordewich, in its first session, the Supreme Court convened for the first time at the Royal Exchange Building on Broad Street, a few steps from Federal Hall. Symbolically, the moment was pregnant with promise for the Republic. This birth of a new national institution whose future power, admittedly, still existed only in the eyes and minds of just a few visionary Americans, impressively bewigged and swathed in their robes of office. Chief Justice John Jay and 3 associate justices, William Cushing of Massachusetts, James Wilson of Pennsylvania, and John Blair of Virginia, sat augustly before a throng of spectators and waited for something to happen. Nothing did. They had no cases to consider. After a week of inactivity, they adjourned until September, and everyone went home. The 6th member, James Iredell, was not confirmed until May 12, 1790. Because the full court had only 6 members, every decision that it made by a majority was also made by 2/3. However, Congress has always allowed less than the court's full membership to make decisions, starting with a quorum of 4 justices in 1789. Earliest beginnings to Marshall. Under Chief Justices J. Rutledge and Ellsworth, the court heard few cases. Its first decision was West v. Barnes, a case involving a procedural issue. The court lacked a home of its own and had little prestige, a situation not helped by the highest profile case of the era, Chisholm v. Georgia, which was reversed within 2 years by the adoption of the 11th Amendment. The court's power and prestige grew substantially during the Marshall Court. Under Marshall, the court established the power of judicial review over acts of Congress, including specifying itself as the supreme expositor of the Constitution, and made several important constitutional rulings giving shape and substance to the balance of power between the federal government and the states. The Marshall Court also ended the practice of each justice issuing his opinion seriatim, a remnant of British tradition, and instead issuing a single majority opinion. Also during Marshall's tenure, although beyond the court's control, the impeachment and acquittal of Justice Samuel Chase in 1804-05 helped cement the principle of judicial independence. From Taney to Taft. The Taney Court made several important rulings, such as Sheldon v. Sill, which held that while Congress may not limit the subjects the Supreme Court may hear, it may limit the jurisdiction of the lower federal courts to prevent them from hearing cases dealing with certain subjects. Nevertheless, it is primarily remembered for its ruling in Dred Scott v. Sandford, which helped precipitate the Civil War. In the Reconstruction era, the Chase, Waite, and Fuller courts interpreted the new Civil War amendments to the Constitution and developed the doctrine of substantive due process. Under the White and Taft courts, the court held that the 14th Amendment had incorporated some guarantees of the Bill of Rights against the states, grappled with the new antitrust statutes, upheld the constitutionality of military conscription, and brought the substantive due process doctrine to its first apogee. The New Deal era. During the Hughes, Stone, and Vinson courts, the court gained its own accommodation in 1935 and changed its interpretation of the Constitution, giving a broader reading to the powers of the federal government to facilitate President Franklin Roosevelt's New Deal. During World War II, the court continued to favor government power, upholding the internment of Japanese citizens and the mandatory Pledge of Allegiance. Nevertheless, Gobitis was soon repudiated, and the steel seizure case restricted the pro-government trend. Warren and Burger. The Warren Court dramatically expanded the force of constitutional civil liberties. It held that segregation in public schools violates equal protection and that traditional legislative district boundaries violated the right to vote. It created a general right to privacy, limited the role of religion in public school, incorporated most guarantees of the Bill of Rights against the states, prominently Mapp v. Ohio and Gideon v. Wainwright, and required that criminal suspects be apprised of all these rights by police. At the same time, however, the court limited defamation suits by public figures and supplied the government with an unbroken run of antitrust victories. The Burger Court marked a conservative shift. It also expanded Griswold's right to privacy to strike down abortion laws, but divided deeply on affirmative action and campaign finance regulation, and dithered on the death penalty, ruling first that most applications were defective, then that the death penalty itself was not unconstitutional. Rehnquist and Roberts. The Rehnquist Court was noted for its revival of judicial enforcement of federalism, emphasizing the limits of the Constitution's affirmative grants of power and the force of its restrictions on those powers. It struck down single-sex state schools as a violation of equal protection, laws against sodomy as violations of substantive due process, and the line-item veto, but upheld school vouchers and reaffirmed Roe's restrictions on abortion laws. The court's decision in Bush v. Gore, which ended the electoral recount during the presidential election of 2000, was especially controversial. The Roberts Court is regarded by some as more conservative than the Rehnquist Court. Some of its major rulings have concerned federal preemption, civil procedure, abortion, climate change, same-sex marriage and the Bill of Rights, notably in Citizens United v. Federal Election Commission, Heller McDonald and Bays v. Rees. Size of the court. Article 3 of the United States Constitution does not specify the number of justices. The Judiciary Act of 1789 called for the appointment of 6 judges, although an 1801 act would have reduced the size of the court to 5 members upon its next vacancy. An 1802 act promptly negated the 1801 act, legally restoring the court's size to 6 members before any such vacancy occurred. As the nation's boundaries grew, Congress added justices to correspond with the growing number of judicial circuits, 7 in 1807, 9 in 1837, and 10 in 1863. In 1866, at the behest of Chief Justice Chase, Congress passed an act providing that the next 3 justices to retire would not be replaced, which would thin the bench to 7 justices by attrition. Consequently, 1 seat was removed in 1866, and a second in 1867. In 1869, however, the Circuit Judges Act returned the number of justices to 9, where it has since remained. President Franklin D. Roosevelt attempted to expand the court in 1937. His proposal envisioned appointment of 1 additional justice for each incumbent justice who reached the age of 70 years 6 months and refused retirement, up to a maximum bench of 15 justices. The proposal was ostensibly to ease the burden of the docket on elderly judges, but the actual purpose was widely understood as an effort to pack the court with justices who would support Roosevelt's New Deal. The plan, usually called the court-packing plan, failed in Congress. Nevertheless, the court's balance began to shift within months when Justice Van Deventer retired and was replaced by Senator Hugo Black. By the end of 1941, Roosevelt had appointed 7 justices and elevated Harlan Fiske Stone to Chief Justice. Appointment and confirmation. The U.S. Constitution states that the President shall nominate, and by and with the advice and consent of the Senate, shall appoint judges of the Supreme Court. Most presidents nominate candidates who broadly share their ideological views, although a justice's decisions may end up being contrary to a president's expectations, because the Constitution sets no qualifications for service as a justice. A president may nominate anyone to serve, subject to Senate confirmation. In modern times, the confirmation process has attracted considerable attention from the press and advocacy groups, which lobby senators to confirm or to reject a nominee depending on whether their track record aligns with the group's views. The Senate Judiciary Committee conducts hearings and votes on whether the nomination should go to the full Senate with a positive, negative or neutral report. The committee's practice of personally interviewing nominees is relatively recent. The first nominee to appear before the committee was Harlan Fiske Stone in 1925, who sought to quell concerns about his links to Wall Street, and the modern practice of questioning began with John Marshall Harlan II in 1955. Once the committee reports out the nomination, the full Senate considers it. Rejections are relatively uncommon. The Senate has explicitly rejected 12 Supreme Court nominees, most recently Robert Bork, nominated by President Ronald Reagan in 1987. Although Senate rules do not necessarily allow a negative vote in committee to block a nomination, prior to 2017 a nomination could be blocked by filibuster once debate had begun in the full Senate. President Lyndon Johnson's nomination of sitting Associate Justice Abe Fortas to succeed Earl Warren as Chief Justice in 1968 was the first successful filibuster of a Supreme Court nominee. It included both Republican and Democratic senators concerned with Fortas' ethics. President Donald Trump's nomination of Neil Gorsuch to the seat vacated by Antonin Scalia was the second. Unlike the Fortas filibuster, however, only Democratic senators voted against cloture on the Gorsuch nomination, citing his perceived conservative judicial philosophy, and the Republican majority's prior refusal to take up President Barack Obama's nomination of Merrick Garland to fill the vacancy. This led the Republican majority to change the rules and eliminate the filibuster for Supreme Court nominations. Not every Supreme Court nominee has received a floor vote in the Senate. A president may withdraw a nomination before an actual confirmation vote occurs, typically because it is clear that the Senate will reject the nominee. This occurred most recently with the nomination of Harriet Miers in 2006. The Senate may also fail to act on a nomination, which expires at the end of the session. For example, President Dwight Eisenhower's first nomination of John Marshall Harlan II in November 1954 was not acted on by the Senate. Eisenhower re-nominated Harlan in January 1955, and Harlan was confirmed 2 months later. Most recently, as previously noted, the Senate failed to act on the March 2016 nomination of Merrick Garland. The nomination expired in January 2017, and the vacancy was later filled by President Trump's appointment of Neil Gorsuch. Once the Senate confirms a nomination, the President must prepare and sign a commission, to which the seal of the Department of Justice must be affixed, before the new justice can take office. The seniority of an associate justice is based on the commissioning date, not the confirmation or swearing-in date. Before 1981, the approval process of justices was usually rapid. From the Truman through Nixon administrations, justices were typically approved within 1 month. From the Reagan administration to the present, however, the process has taken much longer. Some believe this is because Congress sees justices as playing a more political role than in the past. According to the Congressional Research Service, the average number of days from nomination to final Senate vote since 1975 is 67 days, while the median is 71 days. Brought to you by WikiVidi Documentaries. Would you like to know more?